Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about a recent approval for a change of employer for an E-2 visa. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. We recently had a change of employer for E-2 visa approved by the United States Citizenship and Immigration Services for a client from Canada. The client initially came in the United States under a B1 status and invested in business in the United States, started a business in the United States in Texas and obtained an E-2 status through a change of status application. After a year or so into their E-2 status, they decided that the business is not really working out and they wanted to invest into a new E-2 business, not a startup this time, but instead to invest by purchasing 50% of a pre-existing and operating business that already had revenues and already had employees, and they wanted to purchase percentage interest in that company and not do an asset purchase agreement. Basically, they wanted to partner up in a pre-existing business by purchasing 50% of a pre-existing business and become partner with another person in that business. Now, when that plan came about, we almost simultaneously, with the investor acquiring 50% in the pre-existing business, we filed an application for change of employer and extension of E-2 status with the United States Citizenship and Immigration Services in order for the investor to be able to work in the new company. Now, we did file the application with premium processing, which allows you to obtain a decision in 15 business days in exchange for paying an additional fee to the United States Citizenship and Immigration Services. Now, despite the fact that the company that the investor acquired was operating and already had 5 full-time employees, the United States Citizenship and Immigration Services issued a request for further evidence in this case, and it was quite an extensive request for further evidence because they had certain concerns, and now we are going to discuss the concerns that USCIS had with the request for further evidence. We managed to successfully respond to this extensive request for further evidence, and the case was ultimately approved. So, with the request for further evidence, we addressed 3 main concerns that the United States Citizenship and Immigration Services had regarding this case. First, the purchase of pre-existing business. Now, the investor already owned about 30% in this business that they were going to purchase. So the United States Citizenship and Immigration Services had some questions regarding the purchasing of 50% of this business because the investor already had 30% and they were technically acquiring 20% of this business, and whether acquiring this 20% and investing the capital was substantial for this pre-existing business. So we provided evidence that the investor was purchasing an additional 20% for $300,000, and that was substantial for this business. Another concern that USCIS had was regarding the bona fides of the enterprise. So despite the fact that the business was already operating for more than a year at that point and had 5 full-time employees and many contracts, the United States Citizenship and Immigration Services was concerned about the invoices that this company was issuing. And the reason why the invoices were different than what you would typically see with the companies, because they were a subcontractor, or they still are a subcontractor in the construction industry. And the way the invoicing works in the construction industry for subcontractors specifically, it is very industry specific. So we were able to document and establish that the invoicing practices were actually correct, and they were pursuant to the American Institute of Architects, which is the entity, the organization that dictates how invoicing is done in this industry as a subcontractor. So we were able to document that, and we were able to provide information about how the invoicing practices looks and how that is pursuant to the American Institute of Architects. And with that, we were able to successfully overcome the concerns regarding the bona fides of the business. And finally, USCIS also had concerns over the marginality of the business. However, this business already had 5 full-time employees, and that is excluding the investors. So we were able to provide more recent financial statements, including profit and loss statements, the balance sheets, the payroll records. We also provided information regarding the value of the equipment and assets that this company had. And with all these financial documents that we provided, including the IRS Form 941 quarterly report, with all these documents we were able to overcome and show that the business was in fact not marginal. Now, the key outcomes in this case are: 1, we obtained an approval for the change of employer for the E-2 status, but also at the same time we obtained an extension of E-2 status for 2 years, which is the maximum period allowed under the USCIS policy. This means that the investor obtained an additional 2 years of E-2 status in order to work for the new employer, meaning the new company that they invested in, where they acquired a pre-existing business. 2, the processing time. The processing time in this case was 3 months, even though we filed the case with premium processing with the United States Citizenship and Immigration Services. And this is because USCIS issued a request for further evidence after the initial review of the case, asking for additional information and documents. It took time to prepare the answer and collect additional evidence to address USCIS's concerns. And after we have finally made a response and sent a response to USCIS, then USCIS reviewed the case and issued a final determination. But that entire period, the overall processing time from the moment we initially filed the case and until the approval, was 3 months. And 3, the investment in the US was successful, meaning that the investor was able to show USCIS that they've invested a substantial amount of capital, specifically for 20% of the pre-existing business. They have paid $300,000. Now the $300,000 were contributed in the form of equipment, machinery and tools that the subcontractor in the construction industry actually needed in order to continue to operate. And finally, a quick reminder, the E-2 Treaty Investor Visa is available to citizens of E-2 Treaty countries that are looking to make an investment in an E-2 business. They can buy, so you can buy a business, you can start a business from scratch, or even invest in a franchise in order to obtain an E-2 visa. The E-2 visa allows you to bring your spouse and children under the age of 21 and unmarried to the United States, and you can also bring an executive, manager or specialized knowledge employee essential to the business operation to the United States to help you run the US operation, as long as they are a citizen of an E-2 treaty country, the same E-2 treaty country that you come from. Now, the E-2 visa can be renewed indefinitely as long as the business is successful and you continue to meet the requirements for the E-2 visa. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.